Now, at the point that I did this study, which was about 10 years back, I mean, it was published around 5 years back. And I did the research around 10 years back. There had already started to be, there was already some kind of critique of PIL that was emerging. But much of this critique was the kind of what I call the neoliberalism argument, the argument that, as Professor Bakshi called it, that there was a kind of a structural adjustment of judicial activism, that there was a PIL was becoming neoliberal just like everything else, right? So the argument, the critique was really more of a consequentialist one, like I say, that, the people who are getting adversely affected by PIL, strangely enough, by the poor, well, the poor were supposedly the principal constituency of PIL to begin with. But I tried to go beyond this. Now, of course, it's evident from the examples I've given that the people who are adversely affected in the instances I give, especially, are the poor. I mean, factory workers, slum dwellers, people like that. And also another example that I give that not discussed here, the auto rickshaw drivers in through the CNG kind of measure that they're put to. Now, the important thing for me is not just that they were adversely affected by the litigation or had to face great amount of hardship because of this litigation, because of these PILs, but most importantly, that they were never heard in these cases. That the process of PIL excluded them, or rather the lack of process of PIL meant that they could never be able to present their points of view, that injustice in that sense of basic right to be heard, to present, basically, if you're affected by a cause of action, you should be able to at least defend your point of view, your position. But they never were given the chance, and even when they were able to muster the resources to be present in court, through with great difficulty getting a lawyer to represent the point of view, the court would often just remove them or just exclude them or just say that we will take into account. We will take your interest into account rather. So this idea, which is something not very different to what happened to the Bhopal victims, right? The state saying that we'll take care of you, we know your interests, and even if you're adversely affected, we are the best judge. That paternalistic argument was somehow accepted, and the PIL process made sure that there was no real recourse that the people could have had against it. Now, if a state government or a municipality orders slum demolitions or evictions, for instance, people can go to court, try to get a stay, try to argue against it. But what happens when the court itself does these things? What is the recourse? There's nothing, right? Especially when the court refuses to hear you at all, because it itself is the party which is causing the damage at some level, right? So I believe while it's true that court had also internalized the kind of neoliberal logic that has pervaded our institutions for the last two more decades. I think it's important to understand that the culpability of the court here is much more. It's not like it is rather the agent of neoliberalism rather than neoliberalism acting through the court. Meaning, what I'm trying to say is that, you see, changes due to neoliberalism has happened, for instance, in many cities all over the world, whether it be Brazil or China, etc. But in India, the court becomes the means to actualize this. So it's much more that than just saying that the court has become ideologically anti-poor or such a thing. That the court is not sympathetic. But the fact that even if it was unsympathetic, ordinarily the court would not be able to operationalize that logic, right? A court, in areas of the world where there's no PIL, it's very difficult for the court to actually carry out such moves, right? It may not be sympathetic to the poor, but it can't do much about them because it doesn't have the powers that PIL has given it. The PIL court has such enormous powers because it is no longer limited by any procedural limitations. We have to understand that procedure also limits the powers of the court, right? The court can't just take up any issue it likes, as it does in India, right? It can just suo motu decide that X is a problem and therefore it wants to deal with it. And then without evidence, it may come up with its own facts regarding that issue, and then it come up with its own solution also, without involving anybody who's directly affected by the issue. So the PIL court enables, the PIL procedure, or lack of it, enables the court to become an incredibly powerful means to carry out whatever agenda it deems fit. And at this point, it was neoliberal, but it could be anything else, right? So I believe it's important that we move away from this consequentialist critique and try to understand that there is, even if we accept the consequentialist critique, we move from the kind of narrow consequentialism of looking at who wins and who loses, but rather look at it institutionally, that what it does to the character of the courts, of the judiciary, when it's vested with such unaccountable powers, right? And that's where we have to understand that the impact of PIL is not just restricted to the cases that we are discussing or to such instances, but there's this logic of how it has pervaded the Indian legal culture more generally. So informalism, like we discussed, has become part of so much litigation in general. So in family courts, for instance, there's a kind of forced mediation that is introduced, that people, even if they don't want to live together, in India, we kind of force couples to live together even if they don't want to, right? We can make it very difficult to get a divorce, as difficult as possible. And to further that process of difficulty, there's a kind of attempts to introduce forced mediation in family courts. And then, of course, local adalats, but probably the best example of this is Ayodhya case, right? And I'm actually talking about the prior judgment. This book, remember, came out before the judgment from 2019. This was the Lucknow bench decision, which decided to partition the property that was of Ayodhya into 3 parts. Now, the interesting thing was that nobody had asked for such a partition. And at some level, the court was acting way beyond its powers in the kind of relief it gave. But the idea was that, it was accepted and celebrated as a kind of a panchayati justice, as a kind of a attempt to a kind of conflict resolution. So this idea of kind of informal settlements to kind of settle Indian problems has taken root very deeply in legal culture, what I'm arguing. And Bhopal, of course, is the best example of them all. So this idea that, there is no way we can actually make the institution work and get two or more disputing sides to actually contest their cases and adjudication come to the solution. But instead, we have to have this kind of jugaad solutions like PIL, and so that's the idea. And in this, actually, underlying all of this is some kind of deep idea of Indian exceptionalism. Now, this is an idea which has dominated much of the Indian political science literature for the last 3 decades, right? So to understand the kind of experience of experience of political modernity in this part of the world, we keep carving out exceptions, right? We keep saying that when Indian secularism is different from the Western secularism, Indian democracy is different, now Indian judiciary is different, Indian constitutionalism is different. So all of these, we keep piling up these exceptions to Indian political experience as being somehow different. So the celebration of PIL was precisely that it was different from the West, and we came up with the Indian solution, right? So this mode of argument, which I say derives an odd proposition from an is that basically we say that, sure, Indian political institutions, whether it be judiciary or any other, are working in ways which are different from the West, but is that necessarily desirable? We see that difference itself as desirable. We move from that is of that difference to an ought, and we do it all the time, right? And of course, this is an attempt to speak back to the West at some level, right? Why should we normativize Western political behavior, Western political norms in India? But what we've instead come up with is we've normativized Indian political behavior. We've normativized whatever happens in politics in India or constitutional behavior in India as fine because it is Indian. So it's an important thing to start problematizing, in my view. Finally, what is the nature of the problem with PIL more in democratic theory terms? Now you have to understand what is the nature of the problem with a populist judiciary. Now, you all know, obviously, any politically aware citizen in India knows that almost all political formation in India are populist in some way or the other, right? It will be difficult to argue that against it. That basically the language of politics in India is populist. So, what is the big deal, you may ask, if judges also become populist? I'll tell you what the big deal is, why it is such a problem. Because the whole idea of a judiciary, right, a constitutional judiciary, is to basically act as an umpire against the excesses of the legislature or the executive, right, to make sure they continue to fulfill their constitutional role. That when a case is adjudicated before a court, like probably the best example is 377, right? Now, why is I'm talking about the first judgment, not the second judgment, which came a couple of years back. I'm talking about the judgment 2013, where the court said, well, these guys are, the sexual minorities are minuscule minorities, so why do we have to worry about them? That idea that we should worry about minuscule minorities, that basically, if we accept the idea of popular judiciary, we accept the idea that the courts have to act as an instrument of public opinion, right? That because sexual minorities may be deeply unpopular or deeply, maybe a small and insignificant minority, therefore they do not need any attention of the court. But this goes against the very idea of judicial review. And this is best articulated by an American jurist called John Hart Ely, who argued that the whole point of judicial review is to make sure that the court can function as a representation reinforcing entity. That is, to make sure, as he says, the first kind of situation, that the government in power, that to make sure that when the government in power clogs off the channels of political change, to ensure that they will stay, that to ensure that this does not happen. That is, the court must especially be careful that the government in power does not make regime change impossible. Now, somebody defined democracy as a form in which parties lose elections, right? If people don't lose elections, everybody has to be able to lose elections for it to be a real democracy, right? If it doesn't, it's not really a democracy. So a party in power will very much be interested in making sure that it may never lose elections. And for that, it may clog off the channels of political change. And he gives three instances of it. That is, first is a kind of a clamp down on political speech to make sure that critical political speech, which allows for oppositional points of view to be articulated, are made difficult. Second example is that he says are examples of election laws that are blatantly biased in favor of the party in power. And the third example he gives are delegated legislation. There are instances where instead of parliament making legislation, you enable the bureaucrats to basically make legislation. And all three instances we can see in India, the courts have been not very concerned about, right? The courts have been not particularly protective of political speech or election or electoral laws, or of course, delegated legislation. So the courts are not exactly interested in performing this role of correcting the difficulties. So basically, these are all attempts to make sure that the problems that may arise from a majoritarian democracy can be undone. But this is not what the Indian Supreme Court is interested in. And the other even more famous aspect of his theory, of John Hart Ely, book called Democracy and Distrust, is that the court performs a counter-majoritarian. That is, as he calls it, discrete and insular minorities. Minorities, let's say like the Parsi, minuscule in number, who are electorally insignificant. But not just electorally insignificant, all minorities who are obviously not able to dictate the terms of politics, democratic politics, which tends to be majoritarian in nature. The court's job is to make sure that it can perform the counter-majoritarian role, to give voice, to enable the points of view of these minorities. Now, the 377 example makes clear how difficult, how far we have come in India from performing this classic role of judicial review. The courts are not really interested in that. A populist judiciary will obviously not be interested in performing the counter-majoritarian role. And that's the crisis of judicial review in India that we've started seeing. I mean, it's become more and more evident in the last few years, but it's really been a long time coming that the court is actually less and less interested in performing the judicial review role. And we have more of a populist judiciary. All of this is really made possible through PIL. The PIL is more of a symptom of this malaise, but it helps us understand the nature of the crisis of the Indian judiciary. And the so-called solution of informalism has actually made things much, much worse. Anyway, I'll end here. I hope you enjoyed and got something out of this talk. I would love to hear some feedback. Thank you.